Yes, except in one special circumstance. So remember that a judicial lien is a lien that was recorded after the creditor got a judgment after successfully litigating a lawsuit against you. And I'm going to just use you generically, assuming that you're the debtor. If you're the creditor, just reverse the roles and use the opposite pronoun. So the bankruptcy code does have a provision that says you can avoid a judicial lien. Now, the word avoid here is a somewhat unusual usage of the word. It means to render null and void. It doesn't mean to shun. So you can avoid a judicial lien to the extent that it impairs your exemption on the asset. Most commonly, this comes up in the context of avoiding a judicial lien against a person's real property, their principal residence, most commonly. What does it mean to impair the exemption? Well, this process you can use in any chapter, but it helps to have in mind this concept of exemption in the Chapter 7 context. So the Bankruptcy Code is a federal statute. It's divided up into chapters. Different chapters accomplish different things. The most commonly used chapter is Chapter 7. And the big picture goal in the Chapter 7 is just to erase debts in one fell swoop. The whole process, in most cases, typically takes between 5 and 6 months from the day we file the petition until the day the court grants you a discharge. All right. Well, because from the creditor's perspective, this is a pretty big hit, there are some limitations. One limitation is on what you get to keep. You get to keep some stuff, but there's at least the potential to lose assets in a Chapter 7. So one of the things we include in a set of Chapter 7 bankruptcy papers is a complete listing of everything you own or have an interest in. And all of your assets get divided into two categories: exempt, non-exempt. The exempt stuff, that's yours to keep. The non-exempt stuff is fair game for the Chapter 7 trustee appointed by the court to your case to seize and liquidate for the benefit of your creditors. We determine whether something's exempt or non-exempt in California by appealing to one of two exemption tables. One table is for homeowners with equity, the other is for everybody else. So let's say you're a homeowner with equity. Well, we'll use that homeowners with equity table. In that table, as with the other table, there's a list of various categories of possessions. Some categories have dollar limits, others have no dollar limits. And one that has a dollar limit is the equity you have in your principal residence. And there's a certain dollar amount of the equity that you can protect. Rather than getting into the weeds on those, the dollar amount, because there are a couple of caveats there, let me just say you've got a dollar amount. Well, let's say someone has recorded a judicial lien against your property. What does it mean for that judicial lien to impair your exemption? Well, the Bankruptcy Code has a little formula, an arithmetic formula that we use. What we do is we take the value of the lien, the balance, how much you owe, of the lien you're seeking to avoid. We add to that all other liens that encumber the property. And then we add to all of that the exemption amount that you could take if you had no liens at all against the property. And we get a number. To the extent that that number exceeds the fair market value of the property, to that extent, the lien impairs the exemption. And to that extent, we can avoid the lien. So that's dealing with judicial liens in any chapter in bankruptcy, but there is one important caveat. If the judicial lien arose as a result of an obligation to pay child support or alimony, can't avoid that. That's stuck. Congress has seen fit throughout the bankruptcy papers, or the bankruptcy code, I should say, to give very special treatment to domestic support obligations. So if you have not been paying your child support or alimony and your ex-spouse has sued you, gotten a judgment against you, and recorded a judgment based on that, then that you will not be able to remove in bankruptcy.